Ken Sterling is hands down one of the best entertainment lawyers in the industry. He is a veteran, but he also has a very unique perspective. He is not just an entertainment lawyer, he is also a talent manager. He represents many different personalities, including Kevin O'Leary, also known as Mr. Wonderful of Shark Tank. I was lucky enough to actually sit down with him for an interview. He was kind enough to give me 2 hours of his time just so he can clarify some issues, share his knowledge, and so that it clarifies some issues involving Asian artists, IPs, AIs that are of international or global significance. So, if you want to know specific topics or listen to specific topics that we talked about, the timestamp should be in the description box. And also, if there's anything that you want to clarify, let me know. I am actually planning on interviewing him again for some more questions because I really have a lot and I only had like an hour and a half with him. So it wasn't enough. Okay, so on to the video. Hi, thank you for being here.
Thank you for having me.
The honor is mine. Okay, so I will actually jump right into it, but first question will be for just for my audience to get to know you a little bit more. So you are an entertainment lawyer, but you're also managing different talents. Okay, so
Correct.
how did the transition or the merging happen?
It's great because I'm going to use some buzzwords here. The symbioticness and the synergies abound between both. So
Right.
we have a boutique talent agency, and we have an interesting roster of folks: Molly Bloom from Molly's Game, Kevin O'Leary from Shark Tank.
Mm-hmm.
We have Mark Randolph, who created Netflix. We have James Clear, Atomic Habits.
Mm-hmm.
So a very interesting boutique,
Right.
one of their field type of agency.
Okay.
And out of those folks and out of those deals and different brands and endorsements and things that come up, there's also some legal work that we do
Mm-hmm.
associated with those things. So there's some connectivity
Mm-hmm.
between the law firm and the talent agency, and then there's also very separate projects that are done at each.
But were you a talent manager first before you were a lawyer, or lawyer first?
So I would say I've always been a lawyer at heart
Mm-hmm.
and always been a deal maker at heart.
Okay.
So I'm really a deal maker, talent agent first, and an attorney second.
Okay.
Being an attorney, having that brain and knowing how to practice the art of the possible and protect my client, I think is really important.
Mm-hmm.
I'm in a lot of deals where different talent has a manager, a lawyer, an agent, maybe a family office person,
Mm-hmm.
a best friend, a parent, you name it. And it gets a little messy. So I think streamlined, and as long as people understand their fiduciary duty to the talent
Mm-hmm.
and that they look after them as not just as a legal perspective, as kind of a member of their family or a member of their tribe, I think
Okay.
is really important.
Okay, but in terms of profession, did you become a lawyer first and then later on said,
Great question. So talent agent first, lawyer second.
okay,
Hmm.
and you decided to pursue law because you realized, okay, this is going to be better for my clients if I am one and the same person, everything in one.
Great question. I actually decided to pursue law when I was very young. I just had to go out and hustle and feed a family and
Yeah.
other things like that.
Yeah.
Yeah.
Oh, okay. All right. So must be interesting. I have to say that Kevin is not my favorite shark.
He should be.
He's probably my second.
Oh,
I go for the nice guy.
you know what's interesting? He actually is a wonderful human. I'll just say this to the audience too. Some of that is a little overdone by the
For the camera,
producers, and
yeah.
I don't want to give away too much inside baseball. He's actually, in my mind, he's one of the most brilliant business minds on the planet. I put him up there with Buffett. I'd put him next to Buffett. I'd maybe put him ahead of Buffett, if you can imagine that.
Mm-hmm.
He's very up on what's going on business-wise, economy. He's also just a really good human. He's very caring. He's direct,
Mm-hmm.
and I actually applaud that. He's not what they make him out to be on the show at all.
I did watch an interview of him, and he did mention that he actually admitted that a lot of the things that he say is really for camera. It's for TV. So I mean, he's a businessman. He knew how to sell.
Yeah.
And at that moment, he was selling himself in the beginning. So, but usually I go for the nice guy. So Robert would be my number one, and then Mr. Wonderful.
I agree. And I'm going to be thoughtful and careful here. I look at people, I look at their family values and who they're still married to.
Right.
And I have a client and friend who started one of the largest tech companies in the world, still married, happily married to the same person after decades. And not that we all have to do that.
Right.
I believe that these are the people who could do whatever they want. They could pull a Jeff Bezos if they wanted to,
Yeah.
and they don't. And that I respect that and admire that.
Right.
And Kevin's one of those humans.
Yeah.
Very family oriented, very about his kids, very about his wife. And I think those are good points.
I hope I can interview him in the future. But talking about controversial statements, so where, as a lawyer, especially in this like very woke era, like how do you advise your talents? Like, where do you stop? Up to what are you allowed to actually say to be controversial and to be talked about without risking lawsuits?
So first, shout out to Ma, because this is a great question that I know you're going to like. My mother is 80.
Mm-hmm.
She's as left as they come.
Okay.
And I'm not being political here. At the dinner table the other night, she announced that we're too woke. And she claims that's what cost the Dems the election.
Okay.
I'm not passing any judgment here. So the answer, and you'll hear this from me a lot. I teach at USC Law School, and this is what we learned in law school and what I teach. It depends. And when I say it depends, look at Kanye West.
Mm-hmm.
And is what he's saying right, ethically, morally, legally? And if you bifurcate those from each other, I guess the morals aspect depends on who the audience is. The ethics audience depends on what ethical standards you'd apply to it. And then the legal standards are, okay, how much can you say and get away with? Are you
Right.
infringing on other people? Are you breaking regulations? So it's interesting. I have law clients who are very happy and amazed when I say to them, look, there's a legal precedent here,
Right.
and I can give you legal advice. Let's put that aside, because at the end of the day, the only way you test that is after hundreds of thousands or millions of dollars of legal costs and reputational damage and other things like that. Let's talk about doing the right thing here.
Mm-hmm.
Are you doing the right thing? And the right thing, it's subjective, although I think we all have a hint of what that is.
Mm-hmm.
So no, I'm not judging. I'm not calling anybody out here. The things that Mr. West says are very polarizing and very inflammatory. So are the things that our president says.
Mm-hmm.
So I'm not judging. I'm not comparing. I'm not passing opinion on it. I think really what we need to think about is who are we as a society, and what's our tolerance for people to do this. So to answer your question specifically, what are the legal boundaries that somebody should consider when we're in a culture that is aware
Mm-hmm.
and evolved? And the answer again is it depends. So let's talk about risk management compliance, which is, there's law, there's the big court cases, there's Johnny Depp and Amber Heard.
Mm-hmm.
There's also compliance, risk management, there's prevention. So my advice to folks is, if you believe that you're in a regulatory situation, that probably you should stay away from comments that would impact people that are aware, or AKA feel that maybe they're in a place of wokeness,
Mm-hmm.
that they would be offended.
Right. Okay, so
but there's this, I guess, um, the question has always been, how much can I say that allows me to enjoy my rights, to exercise my rights, without legally crossing the line? Because I guess for a lot of people, they're okay to be controversial. They're okay to be, for as long as they do not get into legal. So, when is there like a material line that you can definitively say, once you cross this, you're you're gonna get sued?
Yes. And what we'll say, and we could talk about Kanye too, is that when he does what he does, there's part of the universe who says that's terrible, that's deplorable, and there's another part of the universe that says yes. And sometimes, whether it's conscious or not, it might be good for the brand in business, it might not be good for the brand in the business. In the United States, we've got the Constitution, we have the First Amendment, we have the freedom of speech.
Right.
And what people don't really understand a lot about the Constitution is that when we talk about freedom of speech, 99.999% of that is government actors. So the government can't suppress your speech. Private actors may or may not be able to suppress your speech. So then it becomes, do you work somewhere that has a policy against saying things like that? Are you at a record label that has what's called a morality or a morals clause that prohibits you from making those statements? Do the people who buy your stuff, your music, your films, your widgets, your face creams, are they going to revolt against you? Most platforms aren't allowing censorship, although it's a very zigzag topic, as we've just seen even in this last election cycle, is we're censoring, we're not censoring.
Right.
We're censoring this, but we're not censoring that.
Right.
So a lot of it, and what a lot of people get confused about is they said, wait, that's against my constitutional right, that's against my First Amendment freedoms, except it's only a constitutional issue if the government's involved. So in other words, if Meta does a new policy that has censorship, most likely they're not violating the First Amendment. What people are inferring, and where we'll see more litigation, is they're going to claim that Meta is doing these policies one way or the other because they're being influenced by the government. So they're going to look for a hook of, how do we make this a constitutional issue?
Okay, got it, got it. Does it change? Does it change when the because they always say that when it comes to a celebrity, then the rules kind of change because you're a public figure. Does it? Okay, my specific question is: does it change when it's a minor involved?
So let's take the first part.
Okay.
So if we're talking, are we talking about defamation?
Yes, yeah, defamation.
Okay. So defamation is, there are several elements to defamation. So it's making a knowingly false statement to a third party without the privilege of being able to say that, and where the other party experiences damages.
Yeah.
So that's defamation, slander, and libel. There are different standards. So arguably, you may or may not be a public figure. And depending on what side of the fence I would be on, I'd say she is, she isn't. When we talk about people who are a public figure, and you are out there in the public and you have a following, and if you sued somebody for defamation, for example, they might argue, well, she's a public figure.
Right.
The standards of proof are somewhat lower if someone's a public figure.
Okay.
Public official, public figure. It doesn't mean that it's completely different. It just changes some of the standards of what you've got to prove and some of the ways that you can recover damages and attorney's fees and things like that. Generally, no matter who anybody is, and remember, defamation, knowingly false.
Yeah.
So it's got to be an untrue statement, and the person has to know it's untrue.
Okay.
So saying bad things about people that are true, i.e. disparaging, is not necessarily illegal. that's where a lot of people get wrapped around the axle in these kinds of cases. And then, of course, as we all know, the ultimate get out of jail free card, if people play Monopoly, is that the real defense, the true pure defense to defamation is if it's true.
Right.
So as long as we say things that are true, regardless if it's a public figure or not, when it comes to minors, then we get into privacy and other things like that. So there are platforms, there are laws, national laws, state laws. Different states have different laws too. And this is what's so complex about media, is that it's ubiquitous. It's everywhere.
Right.
And maybe the minor lives in Florida. Maybe the platform is YouTube, headquartered in San Francisco or outside of San Francisco in San Jose. And maybe the servers are in France. Where's the harm happening? Maybe in all of those places. The viewers that saw it the most are in Australia.
Right.
And you look at all these cross-jurisdictional things and all these potential different violations.
Okay. Well, now you mentioned another country. So just want to clarify first. So you're saying that the age of the person, the subject, the one who's probably going to sue, doesn't really matter as much as the material evidence. So the rule doesn't change whether you're a minor.
It does if there are regulations regarding privacy. Are we talking about a minor who's in the public eye? So the content matters.
Okay.
And there's opinion, and there's a knowingly false statement.
Right.
So I want to reframe this a little bit. Let's say somebody says a kid is healthy or a person is healthy. Is it a true statement? Maybe an objective standard could be applied there, and maybe the person would say, hey, I wasn't making a knowingly false statement. I was offering an opinion.
Right.
And this is where things get a little murky. And again, that's probably more disparaging than defamatory. And we, unfortunately, Western culture, there's a lot of body image, there's a lot of body shaming, there's a lot of bullying around these kinds of things, which, candidly, look, I'm a parent, I'm an uncle, I'm a kid. All of those things are not nice things.
Right.
Unfortunately, they're usually not actionable.
Okay. Got it. Okay, so now you mentioned another country. So for example, if the crime doesn't happen in the US. Sorry, if the crime happened in the US but the person involved is not an American. So where is the jurisdiction?
So, couple clarifications. Alleged cause of action. If it's a crime, that would be criminal. If it's breaking the law, if it's defamation or other types of things like that, we'd call it a cause of action. It's very dependent on jurisdictions, and it's very dependent on jurisdiction. Essentially, is based on where the parties are or where the harm takes place.
Okay.
And this is somewhat universal in most legal systems. So, in other words, if we're talking about, let's say, an artist in Korea who then comes to the United States and maybe they're on tour and somebody in the United States says something, and let's say defamatory, not derogatory.
Yeah.
Most likely the right jurisdiction and venue for that is going to be here in the United States.
Okay.
And most likely in the state where it happened. In order to move from a state court to a federal court, there needs to be different prongs. It needs to be over a certain amount of money. It needs to have a diversity of jurisdiction where you've got people in different places. And people often think because it's international in nature that maybe you have to go to federal court. You can sue people in an international jurisdiction in a state court.
Okay. So what if it is switched? What if the parties involved, for example, the one that got defamed, and it is defamatory, is in Korea, and it happened in Korea, but the one who defamed is an American. Is there like a bipartisan I don't know what it's called, like an agreement between...
Treaties.
Yeah.
So there are a couple different treaties, and I will confess I'm not 100% up on Korean law. I'm reasonably certain that Korea is part of the Hague Convention. And the Hague
They are.
Convention, the Hague, there
Yeah.
you go. So the Hague Convention is a very elegant legal agreement between countries to enforce judgments, subpoenas, to allow these countries to do commerce together. I mean, there's a lot of, we need to understand that the lawmakers in all countries are not poor people. And a lot of the regulations and laws and taxes and tariffs, and I'm not going to go too much on tariffs right now, a lot of this really relates to economic gain.
Right.
So the reason that countries like Korea and the United States would be part of the Hague Convention is actually to have commerce free more positively, and to protect interests and to allow people to collect judgments. So now that we've established Korea as part of the Hague Convention, most likely the person that made the statement is in the United States.
Yeah.
And and this was on social media?
Could be, yeah. Or Billboard, for example.
Okay, so Billboard, who's headquartered in the United
In the
States,
US, yeah.
there's enough there where the proper jurisdiction for that's probably in the United States. Now, what I would say is that the person in Korea that had the situation, they would want to hire a U.S. based law firm, and likely a law firm based in, I would just say this out loud, California or New York. They tend to be artist friendly. They tend to go after the bad guys.
Right.
No judgment, folks.
I
And
am very much judging Billboard. Okay.
understood. And I again, I don't know exactly where they're based. I would guess they're probably based in New York or California. What's very, very interesting, though, is platforms typically aren't liable for content that's published by third parties.
Right.
If it's one of their editors or one of their journalists, potentially, and again, there's these standards that come up. And what's very interesting, and this just went through SCOTUS about 2.5 years ago, the Google v. Gonzalez case, which we're not going to go into the gory details. There was a YouTube video. There was a family that was involved. And it upheld what we've known about Section 230 and what we generally believe about the publisher's privilege is that if it's third-party content, and as long as the platforms have guidelines for flagging illegal
Right.
posts and taking those down, that generally they're not responsible. Now, what was interesting about Google v. Gonzalez is that there were allegations that the algorithms of YouTube were doing certain things and that they were weighted towards showing certain videos that had certain violent content and other things like that. Again, SCOTUS said, hey, publishers, platforms, and this goes back to AOL decades ago,
Right.
where similar things had gone on. And SCOTUS said, hey, if you're a neutral platform, you're kind of like a bulletin board. And for those of us that remember bulletin boards, electronic bulletin boards, it's the same thing. When we talk about a bulletin board, when you go to your market, not Irwan. If you go to, I love Irwan, but they don't have bulletin boards. If you go to your local markets, they still have bulletin boards.
Right.
And you can't really, people put stuff up. They take a pin, they put a thing up, and you can't really control that content. Maybe at the end of the day, the manager might take something down, but there are moments in time where people can see that content. And it's the same argument here of, hey, we're just a bulletin board. People
Right.
are just posting things here, and we believe in the freedom of speech,
Got it.
and we're not going to censor.
Yeah.
They're not required to censor.
Just a clarification, Gonzalez v. Google LLC centered on whether internet platforms like Google, YouTube, TikTok, forums, websites could be held liable under U.S. Anti-Terrorism Act or ATA for algorithmically recommending questionable content posted by third parties and whether such actions are actually protected under Section 230 of the Communications Decency Act of 1996. Section 230 is a provision which generally shields in online platforms from liability for content created by users. So in this case, what the Supreme Court did was not really decide on the issue. Instead, it sidestepped the issue by referring to a similar case. It was Twitter versus Stamne, where it held that similar ATA claims against social media companies, but they failed to prove that the platform, which is Twitter at that time, knowingly aided terrorism. In other words, according to the Supreme Court, unless the platform or the website is actually knowingly pushing questionable content, then they're not held liable for whatever, for what could happen because of the content posted on their platform.
But you can, for example, if the owner of the channel, for just for example for YouTube, the owner of the channel doesn't want to reveal their identity, you can go to court and ask the court to ask YouTube or Google to reveal, right?
You can ask. You can ask for anything, folks. You may or may not get a response. And we deal with this a lot at the media practice. 30% of the work we do is defamation work.
Yeah.
And a lot of times it's people, and I call them trolls. I don't, we all know those are the ugly monsters that live under the bridges.
Right.
And I think trolls personify that. There are trolls. So there are people who openly, this is my name, this is my picture, this is the real me, and they say things, and that's pretty easy. A lot of times there are trolls that post things. The only way to get their identity is to file a lawsuit,
Right.
issue subpoenas, work with the legal requirements of that platform, get an email address, a username profile, the date the account was created, and maybe an IP address. Then you take that IP address, you run a trace on that, and then you go back to the ISP, the internet service provider, Comcast, Cox, if you're lucky, and if they weren't using a proxy that was masking the IP address, and then maybe you find out it's some person in a tract house in Folsom making these posts.
Right. Right. But if this is like, if it is a paid channel, like a monetized channel, the identity, Google knows the identity of these people. So can't you ask the court, just reveal the identity of this person so we can sue them?
So you can file the lawsuit, issue the subpoena, and get as much information as you can. If it's a paid channel, there might be other ways to figure that out. And there are, my friend Eric O'Neill is he was at the FBI. He's the one that took down Hansen, the biggest spy in the history of the United States.
Yeah.
So Eric has a very boutique cyber investigation practice. They're pretty good at tracking these things down. It is not inexpensive. And we've been contacted by major celebrities who are in the news about certain things that are out there because there were bots on social media amplifying messages that they didn't want to have amplified. And it turns out it was people from competing brands and competing labels and other things like that.
So that's my next question, actually. If I am a celebrity and I want to do black propaganda against my competitor or something, that's not illegal. It's unethical, but it's not illegal, right?
I'm going to say it depends. If I'm on the plaintiff's side, if I'm on the person being injured, I argue absolutely illegal. Because it's not just that we're on the schoolyard and I said, I don't like your red jacket.
Right.
It's that I go out to the world and I say, you're doing bad things, I'm amplifying things, maybe I'm defaming you, maybe I'm putting you in a false light, maybe I'm invading your privacy somehow by revealing some things that I'm not supposed to reveal. And maybe I'm doing it for an unfair business advantage. And there are causes of action in civil suits when people do things solely for the purpose of, and I take that back, not just solely for the purpose. The primary purpose of their actions is to harm a competitor, those are unfair business practices. And then it becomes illegal.
And you prove that by presenting evidence that your business are being affected, that your income, because that's the only material evidence, right?
So showing harm is very important in these kinds of legal cases.
Right.
Reputational harm, economic harm. There are expert witnesses brought in, and it's not always as simple as whipping out the bank account and saying, before this happened, I had $9 billion and now I have 7 cents.
Right.
It's never that easy, and it usually isn't that bad. And even if you actually look at Johnny Depp and Amber Heard and what they alleged and what came out in court, and Johnny's now back making movies again and had a lot of fan support and a lot of things there. I guess the question is, what were his true economic damages? So there were heads of studios that said, "Hey, Johnny, you're toxic right now. I can't hire you."
Yeah.
That you could probably prove economic damage, and he did.
Yeah.
It's very complex. For all of us who watched all the testimony, I was glued to that for lots of different reasons.
Right.
And that is very complex. People also got a view of what a real trial is like.
Right.
A lot of waiting, a lot of boring stuff, a lot of fidgeting, a lot of papers, a lot of very procedural things going on.
Right.
And at the end of the day, proving damage and harm is actually a lot more difficult than people say. We get calls all day long of people, so and so said this about me. It's like, oh, I'm so sorry. I'm so sorry to hear that. And I'm damaged. Like, oh, I'm so sorry. And how has your business been impacted? Well, I just know because I'm not getting as many customers. Like, okay, can I ask a question? What were your revenues before this happened? XXX. What are they now? XXX plus 10%. It's like, okay, it's going to be really hard to demonstrate that you've been harmed economically here.
Yeah.
It's not impossible. It's challenging. And I share this with people a lot. The American legal system, I think, is very elegant and it's very fair. We all have a story or heard a story of someone who got railroaded. And I'm not talking about the criminal justice system. The civil courts, the approach, the procedure, the remedies are very balanced and appropriate, I believe.
Okay. All right. Okay. So let's move on after this. So too much into defamation.
Yes.
Okay. Let's move on to IP.
Yes.
IP and celebrities.
Intellectual property.
Yes.
Yes.
Okay. So first question: on this subject, how do celebrities typically protect their names, images, and personal brands through IP? And because I always hear this, like liking, image, and name. Likeness, image, and name. So is there a difference between the three?
So NIL, name, image, and likeness, which is really interesting because a lot of people didn't know what that was until a couple years ago when the College Association approved college athletes on NIL deals. Name, image, and likeness has been around forever, and it's your name, it's your image, kind of your brand / likeness, or things that are like it. So is it a photograph of you? Is it a filtered? Did somebody do a sketch of you? Are they trading on your name, image, and likeness? Are they infringing your name, image, and likeness? Are they diluting your name, image, and likeness? Are they misappropriating your name, image, and likeness?
Okay.
So it's very, very complex. I know you have other questions around this, which we'll probably unpack.
Right. Okay. So is that an innate right of everybody, even if you're not a celebrity? Do you have a right over your name, your image, and likeness, even if you're not a public figure?
It depends.
Okay.
And
you really are a lawyer.
I am, and I'm a professor. And I think that's important because we are seeing this shift a lot in the last, thank you, Steve Jobs. We're seeing this shift a lot since the mid 2000s. And part of the reason we're seeing this is that it used to be that the paparazzi were out there with big zoom lenses, and it used to be that there were 3 news stations and 10 newspapers. Now everybody's a reporter. Now everybody's a journalist.
Right.
Now everyone has content. Now everyone can take pictures. Does that mean that it gives people a license to misappropriate name, image, and likeness? No. It means that the lines are getting very blurry. And I say that because somebody's name, where is the name being used? How is it being used? Is it, I saw this celebrity name at a nightclub. I took this picture. You're out in public. You're a public figure. You were really there. We didn't doctor anything. We merely reported what's going on. We're actually journalists. We're posting news, even if it's on our TikTok feed. Where it starts to get interesting is when somebody takes that celebrity's picture and then they put it next to a pair of tennis shoes. And by the way, you don't have to commercialize things to be liable for misappropriating someone's name, image, and likeness. This is so a lot of people think, oh, well, I didn't monetize it,
Right.
or I only did it at school, or this wasn't for the public. People do it. People put celebrities on pitch decks all the time. I'm part of lots of pitches and things like that. And I don't really say this, but I know just because you're in a private room with 7 people and you're not publicly disseminating, or maybe you're not commercializing something, you're still infringing. Unless you have permission to use the N.I.L, name, image, and likeness, which most likely is licensing the image from Getty or Photoshop or Shutterstock or something like that.
Yeah.
Unless people have permission, they're not really supposed to use it. And the classroom exemption or the I wasn't making money, it doesn't actually hold. Now, that's the law. In practice, I haven't seen people chase after students at USC and say, hey, you used my
Right.
picture on that Canva deck, and you better give me my 9 cents.
Yeah.
So I think in practicality, I'm not advising anyone to break the law. In practicality, it works out. When we're talking about big picture infringements of NIL, it's fairly obvious.
Okay. But so just to reiterate or maybe clarify the one, even if I'm not a public figure, do I enjoy rights over my NIL?
You do. And for example, we sat down here and I signed a release.
Right.
And every time we go somewhere, even sometimes when we go to an event, they have us sign something. Your image might be used.
Right.
Your photograph might be used. So maybe somebody didn't sign one of those. And maybe their picture ends up on Facebook. And they get upset and they want to sue somebody. Then it's this very interesting standard of, well, wait, you saw the cameras there. You saw them taking pictures. You've been at this before. You've liked pictures of other people. So it's this very it depends thing. Legally, at the end of the day, if we are using someone's image, or if we're using their name, especially if we're trying to gain credibility or an endorsement or something, whether somebody's famous or not famous, if someone doesn't have permission to do that, it's probably not okay. Now, it comes down to damages. Okay, how did this harm you? How did this dilute it? How did we make money on this? Or were you at a nightclub with someone you weren't supposed to be? And you got in trouble and now you're mad at us and you want to say there's damages? Probably not going to work. And by the way, I'll take that out. Let's say somebody does go to a nightclub and they're with somebody they're not supposed to be, wink, and the significant other sees that and they divorce them and they lose $10 million in the divorce settlement. You're not going to be able to recover on that.
Okay. Got it.
Is that helpful?
Yes. Yeah. No, there is this famous celebrity whose picture was taken by another celebrity, and he was in the background with somebody else, with someone that he wasn't supposed to be with.
Not the first time or the last time that will happen. So, folks, just govern yourselves accordingly. Yes.
Now, if somebody creates a merchandise out of you using your likeness or your name or your image, and you did not allow this, do you have a chance? Like, can you sue that person? And then the other side of it is, if this person who's making all of this merch is not in the U.S., outside of the U.S.
Let's take that as a two-part question. The first question is, can people make merch of somebody else that appropriates their name, image, or likeness? Can they commercialize that or not, even if it's a flop? Can they misappropriate someone's N.I.L to make things? The answer is no. It doesn't matter if you made $10 million or you lost $10 million or you never sold anything. Actually, I take that back. If you make it at home and you never put it out into the open world and it's never in open commerce, it's probably okay if this is your hobby. And the other exception here, and there's parody and there's satire, and there's two different standards there. If you make a bobblehead that doesn't even remotely, like, people kind of know, and they can infer that maybe it's that person, it might be okay. The minute it's very clear to folks, and the minute that you're trying to capitalize and commercialize on that, that's definitely not recommended.
But if the manufacturer is outside the U.S.?
So that's the second part of the question.
Yes.
And we're talking about somebody who is United States based?
The person that's being infringed, whose N.I.L is being...
Yes. So I'd still say not good. And hopefully the country where it's happening is part of the Hague Convention or another treaty with the United States. These protections are very substantial, and I think they should be. And I can share that I have a lot of clients that we do international contracts and agreements with, and I let them know, even when the countries are in the Hague Convention, I just want us to be really clear here that we're getting into very murky territory, and it's going to be very hard for me to go track these people down if they do you dirty.
Right.
You're talking about something where there is no agreement. You're talking about a manufacturer overseas who makes the bobblehead or prints a poster, and that's downright illegal. Enforcing that can be challenging, and there are different remedies. There's money remedies and there's injunctions. So that would be, you get a court order to make people stop. So the challenge is, you might file here in the United States and you might get a restraining order. Who's going to get on the plane and go over to that factory and serve that factory, and which country is it? And even if they're part of the Hague Convention, what's the mayor of that city like? What's the governor of that province like? What is the local dignitary's policy on these kinds of things? Are there creative accounting practices in that region where certain officials get brown bags with currency to look the other way?
Right.
So it becomes very hard. Letter of the law of the United States, it's highly illegal.
Okay. Does the CDO work? Is it like, why not do a CDO first before, or why should you do a CDO first before suing anybody or getting an injunction?
Are we talking about a cease and desist?
Yeah.
So a cease and desist is it's not a mandatory compliance order. It's a letter from a law firm.
Yeah.
To whom it may concern, cease and desist immediately, destroy all the merchandise, send us pictures, send us back serial numbers, send us your P&Ls and things like that. So yes, if it's a manufacturer here in the garment district in Los Angeles, you've got a pretty good basis for going in there and getting things taken care of. If it's overseas, it's just very, very hard to do that. So the cease and desist letter, there's not a requirement to comply. People should reply. I'd call it what we call a shot across the bow. It's a warning shot.
Right.
Once you have that restraining order, then the question is that restraining order enforceable in another jurisdiction? And it's challenging. I'm not going to say impossible. When we talk about restraining orders, it restrains liberty. And even in the United States, to get a restraining order, you have to show there's immediate and irreparable harm, that the restraining order is the only remedy at this time that will stop that immediate and irreparable harm.
Okay.
So that's our standard.
Right.
Maybe in another country, maybe these kinds of things are okay. Maybe getting this restraining order enforced in another country will be really, really difficult.
Okay.
And this stuff happens all the
All
time.
the time. Yeah.
Yes.
Okay. Since you're also a manager, what is the common split? If you're signed to a manager and to how much does a celebrity actually earn in terms of percentage? I guess is.
In terms of a management or an agent,
Yeah. How much does the celebrity get? The one who owns the N.I.L. And you as a manager, how much do you get?
sure. And there's a lot of different parties in these situations.
Right.
So there's either a production that's involved, maybe there's an endorsement deal, maybe there's a book deal. So typically, and different talent agencies and management agencies, some of them are registered. And when they're registered, they're mandated in terms of the maximum percentage that they can take.
Okay.
So there's a lot of agencies out there who don't register. I'm not going to comment on whether that's a good thing or a bad thing. Generally, and I can speak in generalities, and I think it depends, and it depends a lot on who's the talent, who's the management, the percentage of the work. The way I look at it, I try to be, in my brain, I try to be fair. So who's doing all the work here?
Right.
Who's creating this? Whose brand? Whose name, image, and likeness? Whose reputation? Who's put in all these years of hard work developing these things? That person should probably get the majority of it. Typically, managers / agents are in about the 5 to 10% range. I would hope that most are there.
Yeah.
It also depends on kind of the deal size. So if someone's a major celebrity, they can go to different places. So generally in the 5 to 10% range, it depends on the deal size. So big celebrity, I'm doing all the work. You're a commodity person, agent, manager. I'm going to pay 5%, 2.5%, 1%, whatever that is. If it's somebody who's out, if it's a micro-influencer who really wants to get out there and that their manager is hustling and knocking down doors, they could earn a much higher percentage. And the key word is earn.
Right.
Management fees should be commensurate with what that manager or agent earns.
Okay. So wait, so you're saying that if you're a huge celebrity, for example, let's just throw in a name, Eminem, right?
Marshall.
Right.
Yes.
I make a shirt using your name, a fashion line. So you're saying that just by using Eminem's name, he gets like 5% per sale. Is that like a fair?
So if we're looking at the transaction, we've got the celebrity. We have a manufacturer. There's probably a licensing company involved there.
Right.
Is the image an image that the record label owned? Is it a photographer? Is there a manager and an agent involved? Usually. So the managers and the agents are getting a small portion of that. The person who wants to make the merch, they need to license it, and they're going to have to pay an upfront fee. They might pay a piece price, or a per thousand price, or some kind of, every time they hit a threshold, they make an additional payment.
Okay.
With license fees.
Got it. So the one who's making it has to, of course, put in the money to manufacture everything, pay the license, and then the managers will get the percentage, and then the celebrity will get just a percentage of the sale.
So generally what happens is the person who comes, I'll call them the manufacturer, the promoter type
Right.
person. Hey, I got this great idea. I want to make these great T-shirts, and we're gonna go and we're gonna get these turtles who are radioactive and they know martial arts and they live in the sewer, and we're gonna give them Italian names, and we're gonna make these T-shirts. So when we look at that, whoever owns that IP. So if it's a brand or if it's somebody's name, image, and likeness, the bulk of the money most likely goes to the person who put the deal together. They're going to pay a piece of that to the talent, and then on the back end of the talent. So in other words, they'll say something, we're going to give you $100,000 up front, we're going to give you 10% of sales. So the 100,000 and the 10% of sales that goes over to the talent, the manager / talent agent who's involved in that would be getting 5 to 10% of that piece. They most likely aren't going to get something off the top.
Okay, got it. What is, and this is going to be the last question for this section, the first half. What is a sunset deal?
Sunset deal is when it's a clause and it's a sunset provision, and it's we do this for a certain amount of time, and then when the sun sets, that part of the deal is over. So you're probably talking about in a licensing deal,
Right.
or an N.I.L. deal. The sunset provision is when we either hit the end of the life cycle, or when we've paid you enough money, or when there's some other sunset event that we define that the payments would stop.
Okay. So it doesn't go on forever. It does, the sun actually sets on that deal.
So it depends. And this is all in the provision. The sun takes forever to set. The sun never sets. The sun sets in 5 years. The sun
Right.
sets in 4 years. The sun sets tonight.
Right.
The sun sets when your new album comes out, or we can go license a new image. So the sunset clause itself is an embodiment of what that agreement is. And then the terms within that would dictate what happens.
Got it. Because I've heard someone say, I think it was Eminem. He says a lot of things. I think it was him who said, like, oh, he realized that at the end of everything, like at the end of the day, he only gets about like 20 to 30% of what, like the gross income. He only gets like 20 to 30%, and that a lot of the people around him would actually get a piece of whatever he's making for the rest of their lives. So it's like, and then I think that was the first time I heard about the sunset deal, because he did say, like, oh, the sun never actually sets.
Well, right. So in other words, we own you for the rest of your life
Right.
until the sun sets.
Right.
Or so the key is defining when sunset is. So, and the thing is, yes, there are musicians, and we hear about this a lot. And, you know, they refuse to make another song, or they only made bad music because they wanted to
Get out of
wait out their contract. There's some truth to that. There's usually other variables involved, and I would hope that an artist would never make bad product on purpose. I don't think that helps their overall brand, and there are usually ways to look at contracts and agreements, and especially now that there's so much more sophistication, there are probably other ways to look at those situations. So back to an artist, and I've never worked with Eminem. I'd love to be your attorney if you want to call me. That's not a solicitation. That's not surprising. Here's the difference, though. If we're talking about a tour, or we're talking about record sales, or a movie deal when he made 8 Mile, it's not shocking to me that maybe in his pocket was 20-30%. Here's how probably the math worked out. Let's call it a tour.
Right. Yeah.
Because usually an artist, a major artist, would take home 30 to 40% of, less than that, 20 to 30% of the gate of the ticket sales. You got to remember, though, that Apple or Budweiser or Lancome or whoever it was wrote them a big check to be a sponsor. And they probably got a pretty nice piece of that too, which is, I'm not going to call it free money, but that's money on top of the ticket sales. So there's a lot of times sponsors now that are sponsoring these concert tours, which is huge. And what a lot of these big celebrities figured out about 10 years ago is they said, wait, okay, I'm getting a check from these brands. Why don't I start a brand? So those kinds of things are happening now where maybe somebody, Rihanna or Lady Gaga, maybe they say, okay, I don't need the sponsor money anymore. I've got so much money and I'm going to have my own line sponsor my tour because I'm really evangelizing for my own brand. So when we look at the $100 or the 100%, off the top, there's promoters, there's the venue costs, there's the roadies, there's marketing, all of those things.
Taxes.
And I was actually going to say, so when someone says I put 20% in my pocket, was that actually 20% before taxes or after taxes? If that's after taxes, they really took home 40%. And that's when things start to, I always say life's not fair. I call it balanced. That's when things get a little more balanced. The other thing to remember, though, is when you've got somebody like a huge musician, lawyers may charge by the hour. They may charge a percentage. There's a lot of entertainment firms that do charge a percentage instead of hourly. There's a business manager. There's an agent. There's a promoter. So if each of those organizations is taking 5 to 10%, that's 20 to 30% right there.
Yeah.
And to put on a tour, to make a record, to make a movie, it actually costs a lot of money too.
Right. Yeah, so that a lot of people, when you're not like in the business, a lot of people are surprised, especially the fans, right? The ones that really care for their idol. They can't believe that at the end of the day, the celebrity will only take home like 20 to 30%, and they feel like it's unfair that they're only taking that much. But even Eminem himself said that he feels that if it wasn't for the 70% that he's not taking, then he wouldn't have had the 30% that he's taking home.
You're reading my mind. And I was thinking that as you said it, because yes, you're only getting 30%. It might be that all those people getting that other 70% helped you get to where you are keeping the lights on, or making this all possible.
Right.
So it's definitely negotiable. Everyone has a choice. Don't sign that deal if you don't think it's balanced.
Right.
And be open to abundance. It's not about what you're giving away. It's about your time and your passion, your ikigai, all these things that really work for you. Are you doing what you enjoy? Are you getting paid? Are your kids guaranteed money? Is there generational wealth? It's probably okay. And I'll still say I still am involved in cases. I still see in the same news that we all watch that sometimes there are managers and agents and other fiduciaries who probably aren't looking out for the best interests of their clients.
Right. Okay. Let's get into technology, AI.
Yes.
Okay. So it is becoming more common now. People can actually generate images of other celebrities and do whatever it is that they want to do with it. In terms of legislation, how protected celebrities are right now against AI, unauthorized AI?
Most legislation, most business policies, most regulation comes out of things breaking, including the birth of our great nation. The Declaration of Independence wasn't because everything was great. It's because things were broken and we experienced this brokenness and needed to set a new standard. AI's been around for a while, actually a really long time, and in different forms. It's really been in the forefront in the last 3 years, and ChatGPT and a lot of the news and things coming out. And by the way, it's not just images, it's video, audio. It's really, really impressive what is being done with the AI today. So to answer your question, we don't have enough today. And we need to remember that there's legislation.
Right.
and there are laws, and then those laws get tested. The cycle for doing this, it's about 10 years. Yes, and it's so interesting because it shows us that maybe our legal system could use some innovation. Now, we need to be careful because things, unless someone's life is in danger and liberty is in danger, and we have those fairly well addressed with the Constitution, we don't want to whipsaw, we don't want to zigzag, we don't want to react too quickly. So I'm not necessarily saying that 10 years is bad,
Right.
because we learn a lot and a lot gets fleshed out. And the concerns about AI related to this conversation today is talent and intellectual property and protecting brand, name, image, and likeness. That's moving very quickly. I don't want to say too quickly. It's moving very quickly, and being able to keep up with that and keep up with what people can do with technology to profit, dilute, infringe on other people's brands it's overwhelming.
Okay. So does this mean that at this moment, a studio can actually AI generate an image of an actor and finish half the movie, and the actor can't do anything about it? At this stage, that's where we are.
No.
Okay.
Now, we all remember the strike that
Yes.
happened, and I was actually out there. I've got a picture. I'll send you. You can
Okay.
put it. It's my favorite picture. I think I was wearing this jacket.
Okay.
I was over at Sony Studios, and I was out in that line. And it's interesting because it was the writers, and then it was the Screen Actors Guild. And what I found interesting, and this was 2.5 years ago, where AI was coming out, and it was definitely a thing. What's really interesting when we look at that is that I don't know that the threat at the time was AI, although somebody was pretty smart to realize AI was going to be the threat.
Yeah.
So to answer your question, 100% no. A studio, not without permission, not without a written agreement, not without paying compensation to that person that they're using their N.I.L, they can't create a movie. So there's a lot of talk about Tom Hanks and some other actors, and that there's been some AI augmentation in some movies and things like that. That's all licensed, and it's done with agreement, with proper compensation.
Okay, so that's good for the actors, but then you also have other professionals whose job may be on the line. Graphic designers, production designers. What's stopping me from just generating Mars through AI and not have to?
So great question. Mars itself doesn't have a voice. Sorry, Mars. Mars doesn't have a voice. There isn't intellectual property protection there for Mars. And then what we get into is somebody whose job it was to create Mars before.
Yeah.
And if they created Mars by hand, and somebody else goes into DALL-E or one of the other graphics programs in AI and says, show me an image of Mars, and it's new, it's original, it's created, and it's displacing somebody, that is not protected. Now, here's what I'll say about AI, and I firmly believe in this, and Zach Cass, who is the head of Go-To-Market, is a good friend and a client. He believes, and I believe, that AI is here for good for humanity, good for abundance. So if you're that person who paints Mars, probably in Photoshop, if you're that person who does it, you're not necessarily going to get replaced by AI. You're going to get replaced by someone who knows how to use AI better than you. So embrace the AI. Figure out how to have AI do those routinized tasks for you so you can be more creative. And maybe you can create some original works of art. And maybe this original, amazing image of Mars that when you look at it from a 3-degree angle, there's a little puppy face in it. And then that concept being put into commerce and being put out into the public, maybe there's something protectable about that.
Okay. I did hear someone, and I kind of agree, that one of the things they think AI is going to do is get rid of the mediocres. So they feel like if you're not the best at what you're doing or you're not innovating, then yes, you do have to be afraid of AI. But if you're good at what you do, they think that you're safe because AI can only be trained by humans. They can't outdo humans.
I've actually been saying this for the last 3 years, and I've said there's one Tarantino, there's one Lady Gaga, there's one Elton John.
Right.
True art, true fame. And there's actually a theory in a book, it's called The Economics of Fame or Economics of Stardom. And this was written 50 years ago, and it talks about there are no substitutes. When someone's at the top of the food chain, they're not going to get displaced. And actually, if we look at social media today, and a lot of the things that you and I scroll through and that we like, at least I can speak for myself, a lot of it's kind of mediocre, and a lot of it's kind of like the thing I saw yesterday, even if it's a cute puppy.
Yeah.
So if it's a cute real puppy or a cute AI puppy, I don't know if that matters, because maybe what we're actually talking about is commoditized. So there's mediocrity and there's commoditized, and some people think they're the same, and they're not, because we actually need commodities. There just happens to be lots of participants in those markets.
Okay. Okay. Well, it's interesting. I do love technology. I'm one of the early adapters of AI. So I'm getting what they're saying, that it will phase out mediocrity, because a lot of the mediocre things that you do, the repetitive things that you do, AI can do it. So you might as well step up your game.
Well, and that's it, is it's a tool. Right. And remember in the 1980s when the PC came out, everybody thought the world is over and the PC is going to replace people. And look at the companies that didn't exist 30 years ago. Look at tech companies that have hundreds of thousands of employees that are all using PCs.
Right.
So there's definitely some fear and hysteria around AI that I think is unfounded. There's a term about people that are technology adverse called Luddites. True Luddites actually hate technology and they want to destroy technology. Right. I don't think we're at that phase. There's a lot of people who are afraid that AI will replace them. And nobody wants to be mediocre, except kind of the middle, the curve, that 66% in the middle of the bell curve is mediocre.
Right.
So if you don't want to be mediocre, use AI as a tool to free up your time to go focus on creative things and get off your devices.
But the AI is on my device.
It is. So that's the challenge. So tell your AI to work for you and then put your device down.
Right. Okay.
Yes.
So I posted your profile in my Patreon, and a lot of them sent a lot of questions. Okay. So many of my, majority, I would say, of my audience is about, professionals like 40 and above. So they're very interested in how the industry works and on certain actual issues happening. So many of them are fans of the boy band BTS. I'm sure you've heard of them.
Yes, I saw them at the AMAs a couple years ago.
Oh, yeah. So it would be great if you can represent them.
Unbelievable. Yes.
Okay. So first question. In terms of, so the management company of BTS, HAGUE, expanded to America. And they got into this, but they managed another group, a girl group, who unilaterally terminated their contract because they said it was mistreatment, and that is enough grounds for termination of contract. So first question is, can a contract actually be automatically terminated? That's the first question. Second question is, are companies in the US, because the contract was in Korea, are companies safe to work with them without having to go through the management company? They're getting sued right now. The case is in court.
We learned this in law school. Sue everybody. Go after the deep pockets and sue everybody
Right.
and hope there's insurance involved. It goes back to the it depends.
Mm-hmm.
Generally, no. There are termination clauses in agreements. Any agreement that I'm involved in, there's a cure provision. And there might be different levels and different thresholds. So, for example, morality clause. Artist needs to exemplify certain personality traits. They need to not get arrested. They need to not have pictures of them doing drugs in a bathroom. These kinds of things. They need to be not publicly ridiculed, or the contract terminates. Some of those might be automatic termination. If somebody's doing something or maybe not delivering on something in a contract, there's usually what's called a cure provision. So the non-breaching party, it's breach of contract. The non-breaching party usually needs to give notice to the breaching party. Hey, you're doing something wrong. You have 10 days to fix this. So all of this gets defined in the agreement. When we talk about unilateral termination, that just means one side says I'm out.
Right.
Generally, that's not acceptable. And the first part of that was this is in Korea and the contract is in Korea. So then the question is, where is that case litigated?
In Korea.
Exactly. And there is in all contracts, or there should be, a venue or jurisdiction clause. Where do these disputes get settled and handled? And as we talked about earlier, there's Hague Convention, there's South Korea, there's the United States. So the idea of we're in Korea, we don't like what's going on, we're going to go to the United States, we're going to change our name, we're going to do different things, we're going to start a new band. These all become it depends questions, because it depends on, okay, are you using the same band name or did you change the name? Are you using the same music or is it new music? Sometimes even dance moves might be subject to intellectual property
Right.
protection.
They changed their name, or at least they're claiming they changed their name. Does that exempt them? Is that allowed? Because nobody can stop somebody from earning money, right? From making a living.
So I'm so sorry to say it depends. We go back and we look at that original contract. Is it international? Is it global? Is it universal? Can they play your music on a satellite up in the space station? Where is the geographic boundary of this exclusive relationship? What do they own? Do they own your music but not your movie? Do they own your music and your movie, not your personal endorsements? A lot of times, these managers will really be aggressive in what we want to own 100% of your life in what's called a 360, the full circle deal. We get a percentage of everything.
Right.
I empathize a lot with people who, into our conversation earlier of, maybe you're getting 30% of $100 million, and there's a lot of other people that are helping set that up. Maybe 30 million is great. By the way, maybe it's not. And maybe it's not 30 million, maybe it's 30,000. Maybe it's $30. Then we start looking at what's balanced and what really feels reasonable in these situations.
Okay. Let's take the point of view of a brand who wants to work with these girls, for example. If you're the attorney, are you going to advise them and say, yeah, go ahead, could work with them directly? Or are you going to say, can we just wait it out until this case is settled?
Great question. So in other words, we're talking about musicians that were in Korea that didn't like their management deal, came to the United States, they're starting a new band, and now I'm Nike.
Yeah.
And I want to sign a deal with them. Remember what I said, sue everybody, deep pockets. If I was an attorney for the brand, I would say I think we should wait it out. There are some brands who like controversy, who figure things out and actually run numbers. And not in the music industry. There's a large tech company from Korea who made a decision several years ago to knock off a phone. and they got in a really big lawsuit over intellectual property. And it turns out that the executives of this big tech company knew that they were infringing. They knew they were going to lose a lawsuit. They knew that by doing what they did, they would make billions of dollars and get so much market share. They still did it anyway. So my advice, if I'm the attorney for the brand, don't do it unless there's this really amazing spreadsheet that shows us that we're going to make a bajillion dollars.
Okay.
And I don't know if that's ethical, folks.
Okay. Next question. So and this happened in the U.S. So there's a 17-year-old, a minor, who's signed a contract with a record label and a management company, N1. And apparently the contract states that they meaning the management company, dictates the weight of the girl, the color of the hair, whether or not you can get a tattoo. And now she's suing because she's saying that, and she signed it. Whoever represented her and her guardian signed everything, and now she's saying that this is not right. I mean, this clauses should not be there. Is that number one? Is that legally allowed for you to put all those things in a contract? And does she actually have a case?
Question: was the contract signed in another country or the United States? So it's here in the United States.
And she's American.
So I'd want to get a little more information. Here's my general thought about it. There are contracts. There are contracts that are void. There are contracts that are avoidable. There are terms which are unconscionable. And in most contracts, there's an integration clause and a severability clause that says if one term is found to be voidable, it does not void the entire contract. So maybe, and we'll talk about tattoos and belly rings and things like that later, maybe those clauses could be stricken out. That most likely does not void the entire contract.
Okay.
And this is very key. And a lot of times when we look at contract law and we look at these cases, there are many facets to it. And so what we're really talking about is, does the artist want to get a tattoo or they don't want to get a tattoo?
They wanted to get.
Right. Because I was going to say, it's one thing if the management company says you have to get a tattoo or a piercing, and that's absolutely no. Where this gets very interesting, and it's another layer, is somebody's underage.
Right. Yeah. She's 17.
And
she's 16 when she signed.
16 when the guardian signed.
Yeah.
And then the question is, where's the guardian in all this? So I'm curious, where's the parent in wanting the tattoo or not wanting the tattoo?
Well, they're siding with their kid.
Okay. Good parenting, maybe not good for business. So that's where it gets very interesting, because the privity of contract is actually with the guardian, not with a minor. So what the minor wants to do, and I actually applaud the parent for taking their child's position. I actually had a minor child who wanted a tattoo, and that's another tattoo was administered with the permission of the mother. So it's a lot of these production companies, these management companies, these brands who affiliate with a person are hiring that person because of something being on brand.
Right.
And when there's a departure from that, it might impact their brand. It might impact sales. It might impact this whole business persona that has been created. So the legal basis of their argument is, we have put time, money, and resources into developing this brand. And by this person doing this, they're interfering with our business. They're harming our business. It's economic disadvantage. So that's the basis of that kind of lawsuit or litigation. where something like that goes, if the purpose of that celebrity's personality was to exude family values and a clean reputation, and there was a lot of money invested into doing that, and there was a lot on the line, I believe the court, and if not the lower court, an appellate court or a higher court, would most likely side on the side of the brand or the management company. You knew what you were getting yourself into.
Right.
They detrimentally relied on those representations. They invested in doing that. Here's what gets interesting. Going back to the defamation, what are the damages? Because the last time I checked, when artists get tattoos and belly rings, their sales go up. So that's, and this is if I'm representing the artist, that would be my argument. You know, this was a personal choice. It doesn't matter. It was concealed. They agreed to use foundation. Or yes, they unveiled their tattoo on stage and their YouTube views went up.
Right.
So there's always many facets to these legal questions.
Right. Okay. Next question. So, and this puzzled me because as far as I know, when it comes to songs, for example, anyone can cover a song. You don't need the permission of the owner of this song. So how is it that some celebrities complain that, oh, this Trump used my song and I did not give them permission, but he can, right?
Actually, folks, you're not allowed to. Not even cover bands and bars are supposed to. So when we slice up a song,
right,
there are 2 copyrights to the song. There's the score, which is kind of the written, I'll call it sheet music. There's the score and there's the performance.
right.
So give me a song that you love.
Lose Yourself.
Lose
Eminem.
Yourself. Eminem.
Oh, yeah.
So first, who wrote that song? Who actually wrote the song? And a lot of times in these music situations, there's a different songwriter. So for example, Bernie Taupin writes a lot of Elton John songs. Prince, by the way, wrote lots of songs. Nothing Compares to You, Sinead O'Connor, was actually written by Prince. And there's the sheet music score, and then there's the performance. So the person who wrote it, whether it was on paper or on a computer or on the back of a cocktail napkin, they own the copyright to the score and the sheet music. The person who performs it actually has a copyright on that performance. So Marshall Mathers, Eminem, whoever wrote Lose Yourself,
He did.
and he did, so he most likely owns that. Now what happens is a lot of times the record labels will buy, as part of their deal, they'll actually own the copyright to the score.
Okay.
And then the performance, again, same thing. That would be a different copyright that gets licensed differently. So there's the music score, the sheet music, there's the performance. Then there's Detroit. Then there's LA. Then there's Dodger Stadium. Then there's Wrigley Stadium. Then there's Wembley. Each of those performances may be its own copyright. And then when you take the copyrights out, there's the right to performance. So technically, when a garage cover band does Lose Yourself, they're not really supposed to do that. They're really supposed to license it. Do they in practice? No. Have I heard of a lawsuit of Eminem being in a bar in Detroit saying, hey, that's my song?
Right.
No. And it's funny because I was actually, I don't want to get anyone in trouble. I was at this really neat fundraiser, and he was an Eminem impersonator. I'm trying to remember what his name was. He was actually really good. He almost looked like Marshall Mathers too.
Okay.
And he was up in San Francisco, and he's doing his whole thing and wearing the hat backwards. And of course, I'm thinking, oh, I don't think you have a license to do this, and this is probably infringement, and part of this is going to end up on YouTube. I didn't talk to the guy about it. So yeah, technically the right to perform needs to be in writing and agreed to, and there should be compensation.
Oh, so all of these people on YouTube covering somebody else's song.
Yes, and it again, it depends.
Okay.
But the idea of, oh, I didn't have the monetization enabled, or oh, I wasn't making money, that's not a free pass. Technically, you're
You're
supposed to get,
supposed to. Okay.
yes.
All right. Next question.
Yeah.
So, for foreign performers performing in the U.S., so are they paying double taxes, taxes here and taxes in the in their home country?
It depends. And it depends a lot on the treaties between countries. So for example, we're all somewhat familiar with NAFTA. So that would be Canada, United States, Mexico, North American Free Trade Agreement. And under NAFTA, for example, someone who's a US citizen, maybe they go up in Canada on tour and they are supposed to register with the CRA, and they might get an exemption where they say, hey, I'm not a Canadian resident. I'm going to claim this revenue on my 1040 in the United States, so don't tax me. Because of the treaty between Canada and the United States, if for some reason the CRA doesn't grant the exemption and the artist pays the taxes up in Canada, due to NAFTA, they can claim that as a credit, almost as if they'd made a prepayment on their taxes in the United States. So to your question, maybe somebody overseas, maybe Korea. I don't know exactly the tax treaties. There is, I am familiar, and I know there is a tax treaty between Korea and the United States. And generally, people are not subject to double taxation. And generally, people are subject to taxation in their home country. It doesn't mean that they don't pay any tax. It just means that they generally don't pay tax in both places. There are some very unique states. California is one, Massachusetts is another, where sometimes there's a little extra that goes to the state
Okay.
on top of things.
Okay. All right. Last question. So why, if you're a celebrity and I write a biography about you or just a book about you, without your consent, is that legal? And can you, if, for example, you don't like the book, can you actually sue me for it and stop publication and distribution?
Instead of saying it depends, I'm going to say it's complex.
Okay.
It's complex because it depends on where the person got the information. Is it in the public domain? Is it history? Is it a documentary? Is it claiming to be on the inside of something? Are they trading on someone's reputation to sell things? Generally, what I recommend, and I've been approached, and I actually passed on representation in a case where there were some siblings, and one of the siblings wrote a story about the family and some things that the family went through.
Okay.
And two of the siblings sued the other sibling because they didn't want that story to come out. It was all true. That one sibling who wrote the book experienced it. It was all firsthand knowledge. They were entitled to talk about what they were going to write about. The other two siblings alleged invasion of privacy and misappropriation and infringement of someone else's life experiences. What I recommend with everything, including if you're a garage band, is get releases and get people to agree that you can write about things or do a cover.
Right. But generally, if all the information you put in a book, for example, is in public domain,
it's probably okay.
Right.
I'm not giving legal advice, and I'm also not trying to pick up clients. People should consult with an attorney, and being thoughtful about different personalities and different egos and how people's lives can be impacted by these things we do with intellectual property and name, image, and likeness. It's really important to be thoughtful about it. If people were more thoughtful, I'd have less work. And I want less work.
Okay. Thank you so much. Thank you. It has been so. But is there anything that you want to promote? You want to say?
Mm.
Do you want my subscribers to visit or go to?
Oh, thank you. Please visit my LinkedIn page,
Mm-hmm.
and otherwise sterlingmedialaw.com. You
Mm-hmm.
can get an idea of what we do. We love artists. We're very artist friendly. We do give sliding scale to aspiring artists and really enjoy being part of the arts.
Okay. And you represent any kind of celebrity, athletes, singers,
Good question.
influencers?
Different folks in different atmospheres and different levels. There's not any one particular that we do. We work with influencers, and some of them are major celebrity influencers, some of them are micro influencers. We work with musicians, we work with actors, we work with thought leaders, and across the board.
Okay.
I hope you learned a lot. I certainly did. There were so many things that I I thought were true ended up not being true. He clarified a lot of things for me. The only regret that I have is that it was too short. But of course, I had to be respectful of his time. It's not like he doesn't have anything else to do. He's a very, very busy guy. So I am eternally grateful for him for actually agreeing to do this interview. So please visit their website, Sterling Media LLC, if you need any help when it comes to copyright, anything. They also do estate planning, IPs, trademarks, or maybe if you need representation, maybe they can represent you. Please go to his website. He's really one of the best in the industry. He's been around, and as I've said, he has a very unique perspective because he's not just a lawyer; he's also a talent manager. So please check him out. Also check his LinkedIn. Go to his website, and I hope to invite him again. So if you have questions, send them my way, and I will do my best to get him on the show again. Thank you so much. If you ended up liking this video, please give it a like, subscribe, and hit that notification button. And of course, share the video if you can. I'm this specific video is actually going to help a lot of people. Also, please follow me on X and also on Instagram. And if you can, please be a member of my Patreon community. It's a vibrant community. We're not just talking about BTS, we're sharing a lot of other stuff. Asian entertainment, music, movies, TV shows. It's an interesting community. You'll be welcome there. See you.